Please be seated. I apologize for the delay. We had some logistical issues, so sorry for the extra delay. But we are back out for miscellaneous number 9, Williams versus Morgan State University. Note for counsel, we do have Justice Watts, who is appearing on the Polycom. So if you hear a question and don't know where it's coming from, I suggest you turn to the monitor because that's the way the sound system works. And with that, Mr. Kenny.
Thank you, Mr. Chief Justice. May it please the court. I think it's interesting that the argument prior to this case today concerned election integrity, because that's really how this case started. My client, Ms. Williams, made a complaint while she was the broadcasting director of Morgan State University that she thought that the university was unfairly influencing the 2016 mayoral race. And in that complaint, she complained that the university was violating federal law, specifically the Hatch Act, and certain regulations that apply to the university as a broadcaster via the FCC. And this case was originally brought by Ms. Williams in the Circuit Court of Baltimore County. The university then removed the court on federal question grounds, and that case went through the district court and now twice to the Fourth Circuit Court of Appeals, which certified the following question of law for this court today to decide. And that is simply that whether the Maryland Tort Claims Act extends to federal statutory claims, including those where the alleged harm is wrongful termination and retaliation for whistleblowing. And we have three principal submissions on why the Maryland Tort Claims Act is broad enough to encompass federal whistleblower statutory claims. The first is the plain text of the scope of the Maryland Tort Claims Act. Under Section 12102, there's a provision that provides that the Maryland Tort Claims Act should be construed broadly to ensure that injured individuals are provided a remedy. Second, the Maryland Tort Claims Act applies to tort actions. There are several cases from this court that find the word tort to be a broad term. Specifically, there are 3 cases, Green versus NBS, Espina, and Hansen, that provide that tort encompasses all civil wrongs, not just those types of torts that were traditionally tort actions at common law. And sort of with this background, we can deduce that the word tort in the Maryland Tort Claims Act does in fact include a federal statutory whistleblower type claim as of the nature that Ms. Williams is bringing.
So do you think the General Assembly intended with the Maryland Tort Claims Act to waive immunity as to claims under federal statutes that have not yet been enacted?
Well, I do think that there are some lessons in terms of what the Maryland General Assembly thought when it enacted the Maryland Tort Claims Act and then the 1985 amendments to that act. First, the original version of the Maryland Tort Claims Act enumerated 6 specific
Right, but what I'm getting at is the American Recovery and Reinvestment Act was enacted in 2000 and was adopted in 2009. So you're saying in 1985 the General Assembly anticipated or intentionally drafted the waiver provision to encompass future causes of action under future federal law?
Well, of course, the Maryland General Assembly could not have known that Congress would have enacted that act later on down the road. But just like future acts of Congress, the Maryland General Assembly could not have anticipated any future amendments to the Maryland Declaration of Rights or Maryland Constitution, but nonetheless, this court has said that Maryland constitutional torts are encompassed by the Maryland Tort Claims Act, and Maryland has provided a limited waiver of immunity for such actions. I think really the answer to your question goes to the intent of the General Assembly, and the intent of the General Assembly can be deduced by the fact that the General Assembly did away with the 6 enumerated torts and provided for tort actions more generally. And so that demonstrates an intent that a broad swath of claims would be available to Maryland citizens for violations of that right.
What about the fact that if we look at the statutory scheme, and in particular the interrelationship between state government 12104 and courts and judicial proceedings 522, immunities and waiver work in tandem with one another when we're talking about state claims, whether they're state constitutional claims, state statutory claims, whereby the General Assembly has evidenced a specific intent to waive the state's immunity, but also provide immunity to state personnel who fall within the negligence standard. Do you think we can discern that the General Assembly would have intended to waive immunity for federal claims where they can't provide protection in the way of immunity for their state personnel for such claims?
Well, the Maryland Tort Claims Act 12104 is a gap filler. And what our position is that Maryland has immunity for various claims against its employees. And what the federal statute here is essentially fill a gap. And that waiver would apply to these claims, given the fact that Maryland's limited waiver under the Maryland Tort Claims Act, I mean, this is not opening up the floodgates as a loophole to sue the state of Maryland. The Maryland Tort Claims Act prohibits claims for punitive damages. It has a damages cap that applies. There are certain standards that apply under that statute that prohibit claims for actions that are outside the scope of the employee's position. And then, of course,
would you agree with me that the General Assembly would have no way of providing immunity to state personnel under any circumstances for a violation of a federal right, a federal claim, that federal statutory claim, if we were to find that, to agree with your analysis of the waiver?
I don't necessarily think so, because the particular statute at issue in this case does not provide for liability against the state employee. It provides for liability against the employer. So I think that would be a question for another day.
But the question that we're being asked is whether the waiver extends to federal statutory claims. It's not related to these specific statutes, which, as your discussion with Justice Gould pointed out, weren't even in existence in 1985.
Right.
So we would be answering a certified question rather broadly and addressing federal statutory claims generally, wouldn't we?
Of course, you would. And I think the point is that if we're utilizing the Maryland Tort Claims Act to get these federal statutory claims into circuit court, the Maryland Tort Claims Act does carve out the immunity in sort of narrow circumstances when it comes to the actions of the employee. And I don't think by allowing these claims to go forward, you're necessarily going to allow perhaps a direct action against those employees if those actions by the employees don't fall under those exceptions that are in the Maryland Tort Claims Act.
Could, under the state whistleblower cause of action in personnel and pensions, in the Personnel Pensions Article 5309, are you able to get monetary damages under that? If you had filed a cause of action and exhausted, can you currently get monetary damages?
You can get monetary damages. With respect to the Maryland whistleblower protection law at issue, I think that raises a few concerns regarding the fact that that is not a coextensive right with the federal statutory rights that we are talking about here. The state has cited Bunch and Cherry for the proposition that Your Honor is putting forth that Maryland whistleblower protection law, or excuse me, the state pensions article provides an exhaustive scheme that sort of supersedes your right to bring a direct federal action. But those cases really focus in on the fact that the underlying state pension law specifically refers to the FLSA and says in the statute that the rights that we're affording our employees under this law are coextensive verbatim with the Fair Labor Standards Employment Act. The Maryland Whistleblower Protection Law that Your Honor refers to makes no such statement about federal statutory whistleblower protections. And there's a few key...
Why does that matter? For the question before us, which is whether the state
Right.
waived sovereign immunity, why does that matter?
Well, I think it matters for two reasons. One, the argument's been put forward by the state of Maryland that Maryland has not waived state sovereign immunity for those claims because under the doctrine that if there's an alternative cause of action available to an employee under the state pensions article, that is the exclusive remedy that employee has against the state of Maryland.
Well, I don't think it's, I mean, whether there's an alternative or not, that remedy has been prescribed by the state as the way you go about doing that, right? I mean, and you know, the Bunch case was all in the backdrop of, you know, Alden v. Maine and whether Congress had the authority to abrogate state sovereign immunity for federal claims, which in the absence of particular authorization in the Constitution, it doesn't. But why does it matter here whether the express federal rules or laws or protections are incorporated within the state rights or not for purposes of looking at whether there's been a waiver of sovereign immunity?
Well, if the state has waived immunity for the federal statutory claims, we would be pursuing this under the Maryland Tort Claims Act and going directly in circuit court. What the state is arguing that, well, you can't do that because we've already encompassed all these similar type whistleblower retaliation claims for employees. And what we're saying is that this federal right is outside of that pensions administrative process, such that process would not actually give a remedy for these particular federal statutory whistleblower claims.
Because are the federal remedies broader than the state whistleblower remedies?
It's broader and it's different. For example, there are a couple of key distinctions. I'll just look at the National Defense Authorization Act. The National Defense Authorization Act prohibits certain disclosures of classified information, meaning you could be retaliated against if you do not follow the particular standards for disclosing whatever issue that you have under these federal classifications. The Maryland Whistleblower Protection Law has no such provision. So hypothetically, you could have an employee, who's a contractor who feels that they've been retaliated against for engaging in some sort of activity related to national classified information. The Maryland Whistleblower Protection Law will provide no avenue of relief for retaliation because there's no standards that they have to allow that person to go ahead and engage in protected activity.
Well, why would we conclude, though, if the General Assembly has not seen fit to provide those additional remedies under state law with a very specific waiver of sovereign immunity in the Personnel Pensions article, why would we expect that they do intend for there to be a federal remedy that goes farther and that there would be a waiver of sovereign immunity against the state for that different remedy?
Well, I think this just goes to the gap filler role that Maryland Tort Claims Act plays. The Maryland General Assembly has, of course, waived sovereign immunity under that Maryland Whistleblower Protection Law, but there are these other federal laws that under Article 2 of the Maryland Declaration of Rights apply equally to all Maryland citizens. And so I think it's inherently reasonable to understand that the General Assembly would provide Maryland citizens who are aggrieved by federal laws with some avenue of relief under that Maryland Tort Claims Act. And it's not an open book avenue of relief. There are real limitations under that Maryland Tort Claims Act. I believe next month this court's going to be hearing a case exactly that, involving the fact that the Maryland Tort Claims Act has limited damage remedies. You can't supersede those. It has limited liability where the behavior of the employee exceeds the scope of employment. So
what is there in the legislative history in either of the amendments of the Tort Claims Act that shows an intent to waive sovereign immunity for federal claims?
We will concede there was no discussion in the General Assembly about federal claims being part of the waiver of Maryland Tort Claims Act. But when the Maryland When the Maryland General Assembly was reviewing these 1985 amendments to the Maryland Tort Claims Act, the goal was to broaden the waiver so citizens of Maryland could enjoy remedies if they were injured. And they demonstrated that by, again, removing the 6 enumerated tort actions that previously had limited that waiver and saying broadly tort actions in general. I suppose, I mean, the deduction from that is if the Maryland General Assembly had to have understood that there would be future actions that would be brought against the state of Maryland that would not be covered by the sort of classic tort claims. And that played out to fruition when this court found that constitutional torts that were derived directly from the text of the Maryland Constitution and Declaration of Rights fell into that Maryland Tort Claims Act.
But didn't those constitutional torts involve conduct that was traditionally be considered tortious, such as assault, battery?
Well,
and so when the assault is by a police officer, that assault rises to the level of a constitutional tort.
right. Well, I think that's true, but it also is true in the context that those constitutional torts come from the text of the Constitution. And absent those texts, you do not have a constitutional tort. What Maryland has argued here is that the federal civil rights statutes that we're talking about are not really sounding in tort, they're sounding in contract, and that's just simply not the way that these federal civil rights statutes are viewed. And I can point the court to Justice O'Connor's concurrence in Pricewaterhouse v. Hopkins, which is a Title VII case, but it's a similar federal employment law case where she describes these federal statutes as, quote, a statutory employment tort. The court also, in Gross, which is an age discrimination case, sort of described the burdens of proof and standards applicable to federal civil rights employment statutes as sounding in tort. And I think...
So we have a bunch of state statutes that are analogs to some of these federal statutes. We have the Fair Employment Practices Act and the Maryland State Whistleblower Law. Am I right that in all of those, the state has provided for a separate waiver of sovereign immunity and separate procedures in order to access the court?
You are correct, Your Honor. Is
there any exception to that?
There's no exception, but I will say that there's a long history of the state of Maryland arguing in federal court, because these cases are routinely combined with federal statutes like Title VII. And once they remove that case to federal court, there's a long history, we studied this in the Royster case, which is a District of Maryland case, of the state of Maryland arguing that the Maryland Tort Claims Act notice provisions do apply to Maryland statutory claims. And I don't see how they logically get to that argument if you don't also say that the Maryland statutory claims are sounding in tort.
So let me pull back to the point I was trying to get at, which is when we're looking at legislative intent, which is clearly what we're trying to discern here, what's the legislative intent behind that waiver, if in all of the state statutes that would be the analogs to the federal statutes we're talking about, the General Assembly didn't think the Maryland Tort Claims Act applied. It went and enacted separate waiver of sovereign immunity and separate procedures in order to access it. Why would we think that the General Assembly intended to include federal statutory claims when it wasn't including the state statutory claims?
Well, I think I have one response to that, at least, which is if the state of Maryland is enacting, the Fair Employment Practices Act, for example, has a separate waiver, like Your Honor says, well, if that statute has that waiver, then some of the provisions, the limitations of the Maryland Tort Claims Act, for example, damages caps, the actions of the employee, those would not apply to Maryland Fair Employment Practices Act. So I don't think it's just simply that waiver is an evidence that the Maryland Tort Claims Act or that those types of claims don't sound in tort.
Well, but that would be the case because the state wanted to provide whatever remedies and whatever limitations and whatever procedures it wanted with respect to those cases. But I guess this gets back to Justice Gould's question at the beginning. Why would we think that the General Assembly would want to itself craft specific rules and guidelines and limitations and procedures for those state claims, but ship off to the United States Congress to do whatever it wanted with respect to the federal claims, and it would just open liability up within the state based on whatever Congress did.
I think the thrust of our submission is this, that the Maryland Tort Claims Act just provides that gap filler, and it does provide a limited gap filler. Again, we don't think that this is going to blow open the doors, and my client couldn't sue the state of Maryland directly in federal court under the federal statutory claims because Congress didn't waive 11th Amendment immunity. It's only in these situations where there's a limited state court waiver allowing persons to bring these claims in state court that this would apply, and we think that the broad reading of tort would apply to the federal statutory claims.
You have gotten to the end of the time you had initially reserved. You can keep talking, but you would be eating into your rebuttals.
Unless there are no further questions, I'll wait till the rebuttal. Thank you.
I don't see it at this time. Thank you, Mr. Kenny. Ms. Bernhardt.
Thank you, Your Honor. May it please the Court. I'd like to address the gap filler argument first, if I might, and that comes from this Court's decision in Proctor, which involved the WMATA Compact. And the gap filler language arose in the context of interpreting Section 12-103 of the Tort Claims Statute, which talks about not waiving or not applying or not limiting any waiver of sovereign immunity that's found elsewhere in the code. But Proctor also focused on additional language in the Maryland Tort Claims Act, and that's language in Sections 12-104, 12-106, and 12-107. And each of those statutes refer to either an action under this subtitle or a claim under this subtitle, speaking of the Maryland Tort Claims Act. And, for example, the notice of claim, no person can bring an action under this subtitle unless first a notice of claim has been given to the treasurer. And the treasurer can pay money damages for a claim under this subtitle. And in this subtitle is repeated throughout the Maryland Tort Claims Act. And so what the Court was saying in Proctor, and also what the Court had said in Harris, and in other cases, Williams versus Maynard, for example, was focusing on the fact that these conditions and limitations in the Maryland Tort Claims Act only apply to actions under that subtitle. And therefore, in the Harris case, the Court held that the plaintiff there did not have to file a notice of claim before bringing an action tort under the transportation article because that has a separate waiver of sovereign immunity, and the plaintiffs were suing under, the transportation article. They weren't suing under this subtitle. And in Maynard, the Court said, distinguished kind of contrasted the language in the Local Government Tort Claims Act, which is, the language that was issued in the Hansen case, which is very broad and says that, a plaintiff cannot bring an action for unliquidated damages against a local government or an employee unless the complainant has filed a notice of claim. And it applies to any action for unliquidated damages. But the Maryland Tort Claims Act talks about, an action under this subtitle. So it's very much narrower. And so to, take Hansen and then apply it to the Maryland Tort Claims Act, under this Court's reasoning in Maynard, that's erroneous because the language of the two are very different. And so, relying on, it's unfortunate that those arguments were made in the Royster and the other case, but the Maryland Fair Practices Act does not arise under this subtitle, Subtitle 12, Subtitle 1, Title 12 of the State Government Article. It arises under Title 20, and the civil action is permitted under 20-1013, and the remedies permitted there are the same ones that are in 20-1009, which is a host of equitable remedies that are not available under the Maryland Tort Claims Act. And the remedies sought here are equitable in nature, by and large. They are not available under this subtitle, the Maryland Tort Claims Act. If you look at the complaint in this case, count 3 is not brought under the Maryland Tort Claims Act. It's brought under these two federal statutes. And, the notice of claim was not given, under the subtitle, the Maryland Tort Claims Act. It was, but it was for count 1, which does arise under the Maryland Tort Claims Act. It's a common law tort. But, the complaint very clearly states it's brought under these federal statutes, it's brought under the common law and under the federal statutes. And, it seeks relief. If you look at appendix, I think it's 27, that's where the relief sought. It's all, half of it's equitable in nature. It's not available from the treasurer, that relief. It's not available under the Maryland Tort Claims Act. Count 3 is not brought under the Maryland Tort Claims Act. And then and then moving to the legislative intent, that's, under this subtitle, that's pretty clear indication of legislative intent. It's, saying that these conditions and limitations apply to an action for personal injury, property damage on the tortious acts or omissions of state personnel in the scope of employment without malice or gross negligence, and only those. And it only applies to actions under this subtitle. It only applies, where the state employee gets immunity. If the state employee or the state personnel is not entitled to immunity, then the state is not waiving sovereign immunity, despite 12-102 wanting to give injured persons a remedy.
Where do you see Green fitting into this?
Well, Green focused on the language, the non-economic damages statute language. It was really interpreting that statute, in conjunction with the Consumer Protection Act. And so it was really focusing on languages like an action for damages for personal injury. It wasn't really focusing at all on the language of the Maryland Tort Claims Act. It was, and it didn't involve state personnel. And what it involved is whether the cap on non-economic damages for personal injury applied to a claim for personal injury under the Consumer Protection Act. And so it was pure legislative intent. And in the context of discussing the definition of tort, it was really focusing on what we think of as the traditional definition of tort. It's not just a civil wrong. For a tort, you need duty, a duty that's arising not out of a contract or a trust or something like that, but a duty that's arising because you have that duty, as a matter of law to, the injured persons who are in the class of people, and you owe that duty. It's not a public duty. It's a duty to a certain group of like people. And then there's a breach of duty, and there's, personal injury or, property damage or death, but it's not, there's not equitable remedies, and it's not, employment. It doesn't arise out of an employment relationship, which is what we have here. And,
Did Green get it wrong in that case? Did it, or is it, how would you deal with Green? It was looking at tortious conduct, right? It was looking at the definition of tortious conduct, and it came up with a definition of tortious conduct that applies beyond what would ordinarily be considered a tort to any civil wrong. Is it limited to the context of that statute in your view? Because of, even though they're looking at the language, tortious conduct is.
Well, but I don't agree that it's an unusual definition is used there, because it was it was quoting Black's, the standard definition of tort, and just because the standard something that is could have been a common law tort if it had arisen in common law, is in a statute, doesn't mean it's not a tort. I guess if you look at, for example, you look at the Adler case, where the court adopted the common law tort of abusive discharge. The court noted that some legislatures had adopted that by statute. And so, a legislature can adopt a tort by statute. It just has to, it has to have all the same elements, duty, breach, injury, and it has to result, I think, in something that would be an action at law for damages. And here, we're talking about something quite different. We're talking about, the treasurer can't give these remedies. And, when you're talking about federal claims, the legislature can't provide immunity to state personnel, and the legislature can't limit liability to a certain dollar amount, and the legislature most certainly can't condition bringing a federal action on filing a notice with the treasurer. There's a Supreme Court case that says that. Casey versus Felder says that. And, some of the cases we cite in our brief, the California case, Williams versus Horvath, addressed that there was a split of authority at one point, but And the New Jersey Supreme Court noted that as well. But one of those cases did end up in the Supreme Court, is Kaser versus Felder. And the Supreme Court said no, that if you bring an action, you have to be able to bring the same action in state court and federal court, and there's no burden on the state court. You can't make the outcome different for a plaintiff, depending on the forum. And so you're talking about cases where state personnel could have individual liability, like a Section 1983 case. The General Assembly can't immunize those employees. All they can do is indemnify them later on, but they can't immunize them from suit. And so none of that, the whole federal scheme of civil rights laws and employment laws doesn't fit into the Maryland Tort Claims Act at all, because the legislative purpose, there's this twin legislative purpose. And the primary legislative purpose really was to protect the state personnel. If you look at the legislative history, you see that the Attorney General testified and talked about that the law at the time was there were some irrational aspects to it, that state officials had immunity for discretionary acts, state employees did not. They were differently treated. It was getting hard to get people to work for the state because of the liability, and the Board of Public Works had the power to indemnify, but they really wanted to make it more rational, which is the impetus for the 1981 legislation was to protect state workers and provide a limited remedy. And the fiscal impact was very much on the General Assembly's mind. The 1981 legislation limited it, limited to the amount of insurance coverage, limited the categories, but the state personnel were still at risk, and it was difficult to figure out sometimes whether the category applied, and so in 1985 they broadened it. But if you look at the legislative history, there's not a hint of any intent to affect federal litigation or federal claims. And they would have been, had they done so, it would have been struck down as preempted. And so, the standard of review generally is that the presumption's against a waiver. There has to be a clear expression of that waiver, and we don't have that here. I mean, the argument in favor of waiver is somewhat convoluted, it seems to me. It requires, using definitions that, of a tort that didn't exist until many years later. It requires taking just the notice provision and using that as a springboard into court with a waiver of immunity, while leaving behind the conditions and limitations, which are completely integral to the waiver. I mean, it repeated throughout the legislative history and the statutory text is, subject to these conditions and limitations. And it's not, but unless you're suing in federal court, or unless you're suing in state court on a federal claim, or unless it's MFIPA action or something. I mean, it's just, it's where the treasurer can provide, originally, for the claim, the treasurer can provide a monetary remedy for personal injury, property damage, or death, and then, if the treasurer declines the claim, then the person can bring an action under the Maryland Tort Claims Act. And if they haven't filed a notice of claim, they need to file under some other, maybe the transportation article, if it was a car accident. But there are conditions precedent to suit, and they can't be imposed on federal claims. And the legislative history and the text of the Maryland Tort Claims Act make it clear that the General Assembly intended that all of these conditions and limitations apply, including that the state personnel be entitled to immunity.
They can't be imposed on federal claims, but is that are you saying that the General Assembly couldn't extend the Tort Claims Act to federal statutory claims?
Well, what I'm saying is that if you look at Proctor, for example, there was a waiver to federal claims, but there were no conditions or limitations attached because they would be unconstitutional. If you want to see,
why would they be unconstitutional? Because this would not be the state imposing limitations on a federal claim. It would be a limitation on the state's waiver of immunity, which otherwise is complete. Why would they not be able to do that if they wanted to?
Well, in in the sense of the Maryland Tort Claims Act, where you've got the immunity. What I was saying was they can't give immunity to the employee, not that they couldn't.
Okay.
That's what I'm talking about, is that, it just doesn't work in the context of the Maryland Tort Claims Act. If you look at the Proctor case, you can see, you can see the difference, because there's no mention of immunity for employees at all. And, you could also look at Title VII of the Maryland Transportation Article and look at the Maryland Transit Administration, the very broad waiver there. And that waiver, the administrator has, the claims go to the administrator, and there's no immunity given to them. The employees it's complete immunity for the employees, and it's just a waiver it's just a blanket waiver of sovereign immunity. There's no limit. But I guess for purpose of federal claims, the Proctor case in WMATA is the better example, because it just waives sovereign immunity, 11th Amendment immunity. You sue in state or federal court, period. I mean, that's the way the General Assembly waives immunity to federal claims. They do it the way they did it, in the WMATA Compact. They don't. It's certainly not the way it's, the waiver in the Maryland Tort Claims Act, where not only does it only apply under the subtitle, but in 12103 it says there's no waiver of 11th Amendment immunity. And if you look at the legislative history, that point keeps coming up again and again. They're not waiving 11th Amendment immunity, and and it's true that that's really, the 11th Amendment really describes the immunity that's in a federal court, but the flavor throughout the legislative history is that what they're really saying is federal causes of action, because, that getting sued in federal court, they don't want to be sued in any of these things in federal court, and they don't want to be sued on federal claims. They're just waiving, waiving immunity under state law in state court, limited and conditional, while granting immunity to state personnel. And the nature of, the nature of discussion throughout is your, classic common law torts. Now, of course, this court extended that in later years to the constitutional torts, but again, that was because of the nature of the constitutional provisions involved. I mean, if you look at the Litz case, for example, which involved inverse condemnation, the court said that that's a constitutional claim, and it involves, I guess you could call it a civil wrong too. I mean, inverse condemnation, it's damage to someone's property. But the court, this court said that the Maryland Tort Claims Act didn't apply to that, the Notice of Claims or the Local Tort Claims Act. The Notice of Claims provisions don't apply, the caps don't apply, because the Constitution authorizes a citizen to obtain just compensation for an inverse condemnation claim, and that claim that doesn't arise under the Maryland Tort Claims Act. That it's almost in certainly for your classic condemnation, it's in the nature of a contractual remedy. And inverse condemnation, the court viewed that in a similar way. It wasn't a tort. Even though it was a constitutional wrong to damage someone's property in that way, in such a great degree that it amounted to a taking. But the court very much thought that it would, it wasn't right to apply the Maryland Tort Claims Act to it, that it didn't really arise under the Maryland Tort Claims Act, which, only, again, the court focused on it only applies to actions under that subtitle. And, it just brings, so I think probably the most easy way to answer the certified question is that the Maryland Tort Claims Act only applies to actions filed under the Maryland Tort Claims Act. It doesn't apply to federal claims. They're not filed under the Maryland Tort Claims Act. They're not brought under the Maryland Tort Claims Act. And then I think that the certified question also, because it involves an employment legislation, it really, you really have to look at what the remedies are that are available to a state employee, because only a state employee could bring, an action under the Maryland Tort Claims Act against the state, an employment-related one, because, if you're not a state employee, then the employment statutes are going to be irrelevant to you. And so here, we have, a separate statutory scheme that has its own waiver of sovereign immunity, which goes to that, the other part of Proctor, which talked about, the sort of gap filler language. And I think what the court was meaning by that was not that the Maryland Tort Claims Act was going to be exported, all over the code to wherever, there was a gap. But what the court was saying was that if there were a waiver of sovereign immunity applicable to the claim, that the Maryland Tort Claims Act, conditions and limitations would not be, would not provide an overlay on that these other schemes stand alone where they have a waiver of statute of immunity. Then you look to their requirements and conditions. And here, the state personnel and pensions article provides state employees with their exclusive remedy. And for termination, this court has repeatedly held that, and the court has, said it's in the nature of a jurisdictional requirement, not fundamental subject matter jurisdiction. But the court pointed out in the Forster case and in Laurel, Racing Association as well, that where there's a failure to exhaust a primary exclusive administrative remedy by a state employee, the circuit court is not supposed to exercise jurisdiction over the employee's cause of action. And
In Robinson v. Bunch, I think it was, one of the issues that Judge Eldridge brought up in that opinion was Article 19, and basically threw that aside, saying, well, because the FLSA remedy is incorporated into the statute, Article 19 is not an issue. Here, we've heard that the federal remedies are not fully incorporated. Does that create an Article 19 issue?
No, because the waiver of the state is entitled to have sovereign immunity, and Alden versus Maine and Seminole tribes say that. I mean, you don't get around state sovereign immunity by saying we want a remedy. So, the remedies that the state provides for a state employee for whistleblowing are modeled on the federal whistleblower law. They're not. They're quite. They're quite broad. It's you don't. Unlike the common law cause of action, where this court said you had to basically call the police, you couldn't report it to your supervisor. Here, you can just. It just says any disclosure, and then a violation of law. And so the whistleblower protections under the state personnel and pensions article are very broad. The employee has 6 months to bring it, and or they can choose to follow the grievance procedure applicable to their unit, which may or may not have as generous a time frame.
Are you aware that there's legislation pending? It's been introduced in the General Assembly to amend the state whistleblower law.
Yes, Your Honor. Yes, I've seen that legislation.
I understand that one part of the proposed bill is to add, I think for the first time, the potential to receive statutory damages. What if anything, can we glean? Maybe nothing, but is there anything we can glean from that that part of the legislation, proposed legislation?
Well, there's legislation proposed every year that some passes and some does not. So I think the only thing I would take from that is that that the sponsors of the bill perhaps feel that simply providing a back pay and restoring benefits and seniority, that there ought to be additional compensation for whistleblower retaliation. But it's really up to the General Assembly. If the General Assembly chooses to provide that, that's fine. But at the moment, the General Assembly has chosen not to provide compensatory damages for state employee whistleblowing, and that's a clear expression of legislative intent in the state personnel pensions article. And it would be contrary to that legislative intent to permit the employee to then bring a tort claim and get compensatory damages, and it would be quite outside the legislative intent to permit the employee to bring an action under the federal whistleblower law and get additional damages, for example, punitive damages and civil penalties and other things that aren't available under state law. I mean, the General Assembly, the legislative intent is replete with worries and then reassurances about the fiscal impact of the Maryland Tort Claims Act, and in the assurances that it didn't waive 11th Amendment immunity, and that it was very limited, and the fiscal impact would be something that the state could manage. And to now interpret it to open the door without any conditions and limitations to claims under federal law, including potential 1983 claims, I think would really turn that on its head, and it would be contrary to this court's instruction that waivers of sovereign immunity be construed strictly in favor of the state and against waiver. And this court has applied that in the context of interpreting the Maryland Tort Claims Act repeatedly. And in some cases, it ended up denying a remedy to the plaintiffs. Some, refused to toll the condition precedent during minority, and even when the state had direct notice of the claim, required in the Condon case, the college student was left without a remedy because the condition precedent wasn't filed. And, the court was aware of 12-102, but the conditions and limitations are there, and it's the sovereign immunity is construed in favor of the state.
You mentioned 1983 actions. How would that work?
Well, I don't think it would under the Maryland Tort Claims Act, but I just think taking the argument to its logical conclusion, that the argument could be made that it waives them too, because it would substitute the liability of the state for the liability of the individual employee. And those arguments are made in other jurisdictions, and they've been rejected because as a contrary to legislative intent, because the legislature wouldn't have intended that, because any kind of immunity or conditions would be ineffective against a federal claim. And so all the cases that I found interpreted State Tort Claims Act not to apply to federal claims, but because of the Constitution, the issues with constitutionality, and no legislative intent to do so. And so, I think that if you look at the legislative history and then the plain language of the statutes, and considering that it's a state employee with an adequate administrative remedy that was not utilized in a timely way, that the certified question should be answered in the negative, that a state employee who wishes to pursue whistleblower remedies has to use the exclusive remedies provided in the state personnel and pensions article, which has its own separate waiver of sovereign immunity and indicates the legislative intent that that's the state employee's exclusive remedy. Thank you.
Okay, I see no other questions, so thank you, Ms. Bernhardt. Mr. Kenney, you have the 10 minutes you'd saved for rebuttal.
Thank you, Mr. Chief Justice. I just have a few comments on what counsel just said. First, regarding whether this claim is brought pursuant to the Maryland Tort Claims Act. I mean, I think there's a distinction there in terms of when you bring a claim against the state under the Maryland Tort Claims Act, you're bringing a tort claim. You're not bringing a Maryland Tort Claims Act claim. You're bringing an assault claim, a battery claim, a condemnation claim. It's a claim in tort, but you're utilizing the Maryland Tort Claims Act as the waiver of the state's sovereign immunity in court. And that's what it operates to do. It waives the state's sovereign immunity for a tort action that falls under the definition of the statute. I think, Mr. Chief Justice, you asked an interesting question whether the Maryland General Assembly could, under the Maryland Tort Claims Act, waive limited liability for federal statutory claims, and I didn't necessarily hear a no answer. And the fact that Maryland can't give a no answer to that really points to the fact that this is a case about the meaning of the word tort action. Because if they have the power to do that, if they have the power to waive liability for a federal statutory claim, then if the word tort action is broad enough to encompass those federal statutory claims, then I think this case is rather easy. I mean, you would fit the federal statutory claim into that tort action, which this court has continuously said encompasses all civil wrongs.
The other part of the answer, though, was that, of course, you couldn't have the trade-off that is at the center of the Maryland Tort Claims Act, because if a federal law made an individual employee responsible, liable, then how could the Maryland General Assembly immunize somebody who a federal act had made liable? So I mean, that's the other part of what the MTCA does that I think the answer was couldn't be done, and that certainly seems right from a supremacy clause perspective, right?
Right. I think it's important to understand sort of doctrinally where our position is coming from on these federal statutes. We're not alleging that Congress in any fashion abrogated Maryland's state sovereign immunity. It just set down a list of parameters when a state is an employer of an employee. Here are the whistleblower laws that apply. Now, Congress, I suppose, in some alternate universe, could have tried to do this under the 11th Amendment. It could have tried to do this under the 14th Amendment. It did not do so. So this statute, the federal statutes that we're discussing here today, only apply in those states that already have opened their courthouse doors to Maryland citizens for claims. And that's all that we're dealing with here. And I think there was a discussion regarding the consumer protection law and this court's decision in Green v. NBS. And I think it's really difficult for Maryland to sort of align the fact that that court found a civil statutory action to be in the category of a tort such that a tort damages remedy limitation apply to that statutory action.
Well, Green involved, what was it, a defamation claim, right?
I believe Green was involving a Consumer Protection Act claim.
Well, I mean, I think that's actually part of the point, right? Green was, Green was lead-based paint, right? Green was paint exposure. But it was, I mean, isn't that, that's bodily injury from an act from, exposure to lead-based paint. Why, is that something that should be read to, basically it's facts, the factual circumstances that were at issue there?
Well, I think if the court were to accept Maryland's position that employment law claims are inherently contract, then I suppose this court could limit Green to that particular type of Consumer Protection Act claim. But they're really not. I mean, as counsel pointed out, there's a tort action in Maryland under abusive discharge or wrongful termination in violation of public policy. That's in essence a whistleblower claim, right? There's a duty, an employee has a duty to act under certain law. They choose to act under that certain law, and they're retaliated against in their employment for acting under that law, whether that's disclosing certain violations of law, refusing to engage in certain prohibited activities under law, and they're retaliated against. And that's essentially what these federal whistleblower retaliation claims are. They're like the tort of wrongful discharge. And this court has already said in a case cited by Maryland that tort, unlike some of the other statutory employment claims, is not in contract. That isn't like tort. And I think that's where we draw the line here is if the court can identify these federal statutory whistleblower claims as sounding in tort action, like a wrongful discharge claim, then they do fit under that Maryland Tort Claims Act limited waiver. And I think there's a discussion regarding whether it's constitutionally permissible for the state of Maryland to put on limitations to a federal action, like notice provisions, time provisions, the types of things that are encompassed by the notice provisions of the Maryland Tort Claims Act. But that's really beside the point because we haven't alleged in this case, or we're not making the point, that the federal statutory claims here affect any waiver of Maryland's sovereign immunity. We say that Maryland has opened up its own courts under these particular provisions. And regardless if we're talking about a federal statutory claim, we're talking about a Maryland tort claim, we're talking about a Maryland statutory claim, those courthouse doors are open, and you must, but they're open only to the extent that you comply with the various provisions of that Maryland Tort Claims Act. So the fact that counsel's arguing that could create some sort of constitutional tension, we think is just a non-point here. Finally, I'll just say this, that I can understand the court's concern that a decision in our favor would essentially be kind of opening up Maryland to a different category of claims that perhaps the 1985 General Assembly at that point didn't envision when it enacted those amendments. But of course, the world has changed a lot since then, and I'm sure there are all categories of torts and police actions and state action that the Maryland General Assembly didn't anticipate that the state of Maryland would be subject to at this point. But there's a safeguard to that, and that those are the limitations of this limited waiver that Maryland has enacted in the Maryland Tort Claims Act. That's the amount of damages. That's the notice provisions. That's the behavioral requirements of the state employee, that they're acting within the scope of their employment. And the fact that we can rely upon those, I think the court could be less concerned of the fact that all it's doing is providing Maryland citizens the rights that they have as citizens of the United States under federal law. And I think
that's maybe the critical part of your argument is this court is sitting here to determine what legislative intent is, not to determine the policy matter of whether Maryland should be open to those types of claims.
Right. Well, I actually don't think it's a policy issue that we're asking you to decide. This is an issue that's directly laid out in the Maryland Declaration of Rights in Article 2, which it expressly provides that Maryland citizens do enjoy the same rights under federal law as any other state and citizen would. So I don't think we're asking this court to make a policy decision. We're just asking this court to fit federal statutory claims under the broad definition of tort, just like every other Maryland statutory claim we argue would also be. If there's no further questions.
Okay, I see no other questions, so thank you both for your arguments, and the court will stand adjourned until 10 o'clock tomorrow morning.